Today, I will be talking about the Indemnity Clause and the entry of foreign vaccines to India. In India, the COVID-19 cases plummeted to about 90% from the peak of the first wave last year, and it appeared to be under control by March 2021. By April 2021, however, India saw the world's worst second wave, with cases exceeding 4 lakh a day, breaking the world record for the most cases in a single day. Vaccinations have not been administered at a rapid enough rate to counteract this second wave. India has administered 150 million doses, ranking third in the world. However, due to India's huge population, just 9% of the Indians have got at least one dose, and less than 2% are fully vaccinated. In this dire situation, one solution to solve the vaccine was to import foreign vaccines like Pfizer and Moderna. They agreed to supply vaccines to India under a particular condition known as indemnity, which protects businesses from liability resulting from possible side effects of the vaccine. India is in a terrible spot, and the talks on this issue are still ongoing. I will be speaking about the indemnity clause, the state's accountability, the outlook on foreign jurisdiction, and the best approach to tackle this issue, in my opinion. So, as far as the indemnity contracts are concerned, indemnity contracts are a special kind of contracts, which are also known as contingent contracts. That is, the liability for this indemnity arises out of the event whose occurrence is not yet available, right? So, the indemnity contracts, in that sense, the liability for the indemnity contracts arises only after a particular damage occurs. So the legal provision for contracts of indemnity lies in section 124 of the Indian Contract Act, which states that a contract by which one party promises to save another party from loss caused to him by the conduct of the promiser himself or by the conduct of any other person is called a contract of indemnity. The party that grants the indemnity is known as the indemnifier, and in this case, that's the Indian government. And the party that receives this indemnity is known as the indemnified, and in this case, that's Pfizer and Moderna. Apart from this, there are certain rights that the indemnity holder has in cases of indemnity contracts, and this is mentioned in Section 125 of the Indian Contract Act. Firstly, that the right to compensation for all damages that the indemnified will have to pay, it arises out of any suit pertaining to matters which the promise to indemnify applies on. Basically, any compensation that the indemnified may claim from the indemnifier is that it occurs after a suit has been filed in a court of law. Secondly, any expense that the indemnified spends to defend or bring a suit in the general conduct of that business, this is also covered in terms of the compensation that the indemnifier will have to provide. And lastly, any compensation or settlement that the indemnified agrees to pay out of the suit in a court of law, right? So these rights, again, are not absolute. The indemnified needs to make sure that none of the orders of the indemnifier are contravened, and there are certain rules and regulations that the indemnified really needs to, take care of. The development of jurisprudence of the indemnified contracts arose with cases like Gunjan Moreshwar versus Moreshwar Madan, which stated that if the liability on the indemnity holder is absolute, the indemnity holder can ask the indemnifier to take care of this liability and compensation can be claimed. However, this might result, if we apply this case's ruling in our present case, it might result in unnecessary expenses for India, which is already facing a huge financial burden amidst the global pandemic. Now, as far as the center stand and the foreign manufacturers stand is on these particular issues, the center stand is that it might eventually grant the indemnity claims of the foreign manufacturers, because all the other foreign jurisdictions of the world, it might be UK, Norway, whatever, they have granted it as well. But it is negotiating a middle ground approach as well. Now, as far as the foreign manufacturers are concerned, they want indemnity as a sort of protection from legal action against them in any case of side effects that arise due to the vaccination being taken by the general public. They want the state to take the liability that might arise from this. So now I'll be addressing the issue of accountability of state. The doctrine of accountability of state is a pretty old one, and the best case that I could find that talks about the accountability of state is Peninsular and Oriental Steam Navigation Company versus Secretary of State for India, where the Supreme Court held that the Secretary of the State will be accountable only for its commercial motive and not the sovereign function. However, so another major issue that arises from this indemnity contract and the indemnity issue arising therein is that the local manufacturers like Serum Institute also have raised their voice, and even they want indemnity. So their argument is that why is Pfizer and Moderna being foreign manufacturers? Just because they're foreign manufacturers, why are they being given a preferential basis for the vaccines? So that's as far as the local players' voices are concerned. Companies like Pfizer and Moderna are just mere producers at the end of the day, and the state being the regulator for the supply and distribution of these vaccines, the state might be held vicariously liable. And this case of vicarious liability is best articulated in the case of state of Rajasthan v. Vidyavati. which ruled that the state was obligated to pay damages since the wrongdoer's actions were not a sovereign function. Now, I'd like to look at some of the foreign jurisdictions and how they've handled the issue of indemnity in terms of the vaccine. So, 25 jurisdictions have, and around the world, like Norway and Denmark, have come up with systems where the state does take accountability, but in a sense that the accountability shifted to the insurance companies. So what happened during the pandemic was insurance companies have actually faced a bit of losses because of rising claims, because of the dire state of health in the country, right? So as far as tackling issues are concerned, the insurance companies can take this liability, and the government can give them tax friendly rates, or can come up with some other schemes that might benefit them, and work out a relationship with these insurance companies, which would take this liability from the state. So in that way, both the liability of the vaccine claims are also being solved, and the insurance companies are also being benefited in this regard. Right. So, as far as I'll just talk about the US's case. In the US, the Vaccine Injury Compensation Program, or the WIC, was established by the National Childhood Vaccination Injury Act of 1986 for addressing vaccine injury claims. So, this is another approach that we in India can, come up with. We can set up a separate code that would deal with only vaccine claims, so that the already burdened, judiciary is not further burdened by these cases as well. Now, as far as tackling this virus is concerned, I feel the most effective way is by developing crowd immunity. This is possible only through mass vaccination and maintaining the health and safety precautions at a large countrywide level. The entry of these foreign players will definitely help in reaching this goal, and the union government has assured its citizens that talks will conclude and that the vaccines will come to India as soon as possible. The only point of friction seems to be the indemnity clause, and I think by learning from other countries, we can tackle this issue too. I hope this video was informative, and I hope I have educated you a bit about the indemnity clause and the entry of foreign vaccines to India. Thank you very much.